Hi, I'm Dave Fries, and I'm here today with my guest Whitney O'Reilly. We're attorneys in the Trust, Estates, and Wealth Preservation section of Unreturner Burke & Fries, and we're here today to give you some breaking news. We try to bring you news that if you're a Pennsylvania resident will be interesting and useful to you if you are thinking about doing or have done trust and estates planning. We use this show as a way to give you alerts as to things that have changed, and that's why Whitney and I are holding papers today. This new law in Pennsylvania is so hot off the press that we wanted to get it right out to you and talk to you a little bit about it. So today we're going to be talking about a very, very recent change in the power of attorney law. A lot of times, whether you have done a will or a trust as the main vehicle for your trust and estates planning, you'll also have done a durable power of attorney. Durable power of attorney is the document that lets someone take care of your affairs for you if you're incapacitated. And it's very, very important. There are both medical powers of attorney and durable financial powers of attorney that let you pick the person who's going to take care of your medical decision making and your financial affairs. And there's recently been an important change, or series of changes actually, in that law. So Whit, you've been through the whole law and you're helping us to work through it and how we're going to be changing our documents and the approach we take for clients. So tell me a little bit of an overview of what's taken place in the law and the changes in the durable power of attorney law.
Sure. Well, this change was actually signed July 2nd, 2014, and most of the changes are based on the Uniform Power of Attorney Act. And some of the main changes are in regards to the execution of the document. You now need two witnesses. So that means,
for people listening, that means what does it have to look like and how does it have to be executed so it's a valid document?
Exactly. And now we're requiring two witnesses and a notary public.
Now, if your clients of ours, you don't have to worry about that particular one because for a long time, we've thought it was a best practice to require two witnesses, and we almost always have notarized the durable powers of attorney. So that one, if you've already done it, should not worry you. There's some other things, though, where you might have to take some action. So let's talk about other changes in the law. By the way, if you're not a client of the firm, you might check your power of attorney. These are things that are often, that you will need to change. They're often done without a notary and with only one witness.
Some other changes are in regards to agents' duties and powers.
Let me just stop you. When you say agent, what do you mean?
So that's the person who's acting as the power of attorney for someone who's not able to act for themselves.
So I could do a power of attorney where I granted you as the agent the right to balance my checkbook, handle my finances, pay my bills, all of those sort of things if I became incapacitated.
Yep.
Okay.
And some of those duties and powers that you have can be modified or waived, and some of those are in regards to preserving an estate plan, things like keeping separate bank accounts or record keeping, things like that.
So let's take a moment and talk about that, because this is one where if you're a client, even of our firm, you may want to revisit some of these things. So on the action items, if you haven't, or even if you have done a durable power of attorney and you've done it recently, because of this new change of the law, you might want to call us if we've been representing you, or if you're with another firm, call them to make sure that you're properly waiving these things. Why would you want to waive a duty like that? Well, one of the things that we often do, and that the attorney Doug Kahn, who heads up our elder law section, suggests that we have clients do, is to provide for Medicaid and nursing home planning in these documents. That would conflict with these new duties, and we have to make sure that it's being properly waived. So if you haven't done a durable power of attorney, absolutely go to your trusted estates attorney and get that done. If you have done it even recently, because of this change in the law, if you want to provide for Medicaid and nursing home planning, you're going to probably want to change or update your documents. Also, in the documents, there's a page that goes on the front and a page that goes on the back. We've been doing this for a long time. Can you talk a little bit about the changes there?
Sure. So that front page is a state-required notice. Some of the language in that has changed a little bit, so that'll be need to be updated. And also on the back of the power of attorney document is an acknowledgement letting the agent know what their duties are. Some of that language has changed, and now that has to be actually affixed to the power of attorney document and signed before the agent is able to use that document.
Yeah, let me clarify that, because people ask this all the time when they come to the office and we're drafting durable powers of attorney for them. They say, do I have to bring my son and my daughter and my grandson who are the agents under this power of attorney? And the answer to that is still no. They only have to sign these before they start to act. But the important thing is, and we've been doing this, they have to be affixed to or attached to the document. But very important, what you're doing is you're signing this paper that is an acknowledgement, or a notice, I'm sorry, that says that you're going to sign the power of attorney and tells you some important things about it. That's changed.
Yep.
And then when the agent accepts and you remind them of all their duties, that's changed a little bit too, because the duties of the agents have changed. So be sure to talk to your trusted estates lawyer about that. Now, this is not effective. Some of these are effective now, but it really doesn't change until
January 1st of 2015.
So you have a little while to go and fix these, but here's what happens. As a practical matter, people that accept these powers of attorney, like banks and trust companies and people drafting deeds for title companies, they get used to seeing the new way in which they're done. And if you have an old one, even if it's grandfathered and still valid, you're probably going to want to update it and fix it. And this law, we think, contains some really some opportunities, but you're going to have to change and adapt your document to take advantage of them. Anything else we need to know, Whit?
I don't think so.
That's pretty much it?
That's it.
Thank you so much for the briefing. Thank you for taking the time with us. Have a great day, and get your power of attorney updated.